In this video, we will understand what can lead to the deportation of an immigrant with green cards after the Supreme Court decision, and which undocumented immigrants will be among the government's deportation priorities after the Supreme Court decision. So once again, good morning, afternoon, or evening, ladies and gentlemen.
Visit our Swat&Vee channel with your questions to see how best we can help you out your process. Please don't forget to subscribe if you're new to the channel.
So, without any further delay, now let's get into the video and find out what the latest updates are on U.S. immigration. The Supreme Court of Justice has declared that green card holders who have permanent legal residence may be deported if found guilty of certain serious offenses, such as obstructing the course of justice. Judges Clarence Thomas, Samuel Alito, Amy Coney Barrett, and Chief Justice John Roberts all supported Judge Brett Kavanaugh's draft of the ruling. The separate opinion written by Judge Ketanji Brown Jackson is in agreement with the decision. Judge Elena Kagan and Judge Neil Gorsuch both fully agreed with Judge Sonia Sotomayor's dissenting viewpoint, which was supported in part by Judge Sonia Sotomayor. The ruling permits the federal government to deport those permanent residents who have been found guilty of specific serious offenses, even if they have been residing in the country for a long time and have built families. According to the magistrate's decision, the convictions for covering up after the fact and attempting to discourage victims from coming forward with allegations of inappropriate sexual behavior constitute offenses serious enough to qualify a person for deportation. Attorneys had claimed that the obstruction necessitated an open inquiry during the oral hearing prior to the decision, but Judge Kavanaugh, who wrote the main opinion in the decision, concluded that was not the case. Even when there isn't an active inquiry or legal proceeding, people can obstruct the administration of justice, according to Kavanaugh. For instance, if a witness gives the police information, an assassin may threaten to kill the witness. He argued that just because the government hasn't yet noticed and launched an investigation doesn't make such an act any less obstructive. Cases of Lamb and Pugin, Fernando Cordero Garcia and Jean-Francois Pugin, both legal permanent residents, LPR, who both received deportation orders and challenged their convictions, had their cases combined, and the penalty was given in response. The Ninth Circuit Court of Appeals determined that the state's imprisonment of Cordero Garcia for discouraging a witness from reporting a crime did not constitute a felony related to obstruction of justice, the highest court of law stated in its ruling on Thursday, because a current inquiry or legal action was not necessary to commit a state offense. In contrast, the Fourth Circuit Court of Appeals determined in the Pugin case that Pugin's state conviction for complicity after the fact constituted an obstruction of justice criminal even though the state offense did not call for the beginning of an inquiry or ongoing proceeding. The magistrates said that federal law mandates that non-citizens convicted of a federal or state felony that qualifies as a serious crime are removed from the United States in the 39-page statement. Additionally, in 1996, Congress amended the definition of a severe crime to include offenses involving the obstruction of justice. What is the subject of the lawful residents who were deported case? The case that resulted in the decision did not involve two cases that were brought together before the Supreme Court. A Mauritius resident named Jean-Francois Pugin is a party to the legal dispute in Pugin v. Garland. He was granted permanent residency in 1989. The second case involves Fernando Cordero Garcia, a Mexican who was granted legal permanent residence in 1925. Pugin was found guilty in Virginia in 2024 for helping to commit a crime involving obstructing justice. In California, Cordero Garcia was found guilty in 2009 of a number of offenses, including deterring a witness from filing a police complaint. Both of the non-citizens were targeted for deportation by the Department of Homeland Security on the grounds that they had been convicted of serious offenses. Immigration judges, circuits, and 4 and 9 appeals boards all supported DOS in both instances. After a protracted appeals process, the Supreme Court, which decided the issue, endorsed Pugin's expulsion on Thursday, returned the quotation, and reopened the courtroom. Garcia's case is sent to a district court for examination based on different standards. Federal or state crimes involving the administration of justice are included in the definition of an aggravated felony. We come to the conclusion that even though a crime does not necessitate an ongoing investigation or process sentenced by the magistrate, it can nevertheless be related to obstruction of justice under the Immigration and Nationality Act. Judge Sotomayor dissented from the decision regarding green card holders. When she disagreed with the standard for what constitutes an obstruction of justice, Judge Sotomayor did not concur with the majority of the court. According to Sotomayor's dissenting opinion, tampering with an existing inquiry or process is at the heart of what an obstruction of justice felony means, from the earliest U.S. laws and dictionaries through federal and state statutes on obstruction. The court ignores this extensive evidence and misinterprets what is meant by obstruction of justice in legal parlance. The judge stated that a portion of the Immigration and Nationality Act was passed by Congress in 1926. Tuggan admitted to helping to commit a severe crime. 9 of the 12 months of his prison term were suspended, considering that he was found guilty of a serious offense. The American government started the deportation procedure against him. The Immigration Appeals Board decided Pugin's conviction was categorized as a crime involving obstruction of justice after hearing the case. Let's now discuss which unauthorized immigrants the government would prioritize deporting in the wake of the Supreme Court ruling. In what has been viewed as a success for the administration, the Supreme Court affirmed the deportation goals of the Joe Biden administration on Friday. Late September of last year saw the definition of these priorities. Alejandro Mayorkas, the Secretary of the Department of Homeland Security, addressed an internal memo to the directors of every agency under his supervision. In response to a lawsuit from Texas and Louisiana, the Supreme Court, Friday, he maintained those deportation priorities, concentrating on unauthorized immigrants who had committed serious crimes. The court decided that when it comes to how the federal government handles matters like immigration law, states cannot contest its choices. Can you currently be expelled for lacking documentation? I emphasized that there are other reasons for removal from the nation in the memorandum that the court left in effect. Being an undocumented immigrant should not be the only consideration, because it was decided to detain and expel the person from the country. The document makes it clear. We establish priorities for civil immigration enforcement so that we can use the resources at our disposal to best achieve our goals. Mayorkas stated that we will give top priority to detaining and expelling non-citizens who pose a threat to our borders, public safety, or national security. The letter gave the administration the opportunity to reiterate the deportation priorities it had set in February 21, with a particular emphasis on aliens who commit felonies or significant offenses. Following incidents at the Del Rio, Texas, border crossing where Border Patrol agents on horseback charged several Haitian immigrants crossing the Rio Grande from Mexico seeking asylum with whips in hand, the U.S. Homeland Security Chief was forced to reiterate the administration's immigration policies. What will the order of deportations be following the court's ruling? The administration would give priority to apprehending and expelling individuals who constitute a threat to American public safety and national security, as well as those who have just crossed the border unlawfully. Farmers, the elderly, and other people at risk of deportation under the Trump administration should not be arrested and deported, the DA's secretary had urged immigration and customs enforcement officers. Even though the cases had not yet been determined by the courts, DHS relied on a strict deportation priority list under the previous administration that featured immigrants who had been charged with crimes. Trump also declared that illegal immigration posed a threat to national and public security and gave immigration officers extraordinary authority to remove illegal immigrants for no other reason than that they lacked the proper documentation to remain in the country. The main concern is if the non-citizen currently endangers public safety. In a 22-page document, Mayor York explains we're keeping an eye on the priority of deportations. The government's deportation priorities have been faithfully followed ever since they were initially released in February 21 and renewed in September 22. According to Mayor York, the division he oversees keeps track of whether or not the rules set down at the start of the Biden administration are being followed. I have faith in the ICE leadership, the ICE workforce, and my personal leadership. I also have faith in the efforts I have made to interact with the ICA workforce and discuss similar issues with them. In a statement, he stated this. He sent the memo in September of the previous year. Texas and Louisiana, both under Republican control, disputed the federal government's deportation priorities, arguing that it had broken immigration law and should be held in detention and sent packing with the rest of the undocumented population. These are the deportation priorities set by the government. DS announced 4 deportation priority categories in January with immediate effect. A national security officer may assume that a non-citizen is a priority for deportation if they have committed or are suspected of committing acts of terrorism or activities related to such acts, or if they have committed or are suspected of committing espionage or activities related to such activities. Or it becomes necessary to apprehend, detain, or take control of him or her in order to safeguard American national security. Priority to border security. If a non-citizen was apprehended at the border or at a port of entry while attempting to enter the country illegally on or after November 1, 22, or if he or she was not physically present in the country prior to that date, a national security agent may assume that person is a priority for deportation. What are the exclusions from deportation? Before carrying out a deportation, agents must determine if the non-citizen now constitutes a threat to the public's safety as well as the scope, seriousness, and currency of the illegal behavior done by the alien. They must also take into account mitigating circumstances such as the person's family situation, medical conditions, community links, proof of rehabilitation, and whether or not there is any prospective immigration support available. Agents must also rely on reliable evidence and collaborate with other federal agencies when drawing judgments regarding a suspect's deliberate involvement in a transnational criminal organization or organized crime gang. Cases involving non-citizens who are elderly or suffer from major physical or mental illnesses should receive extra attention from agents. The DHS claims that there must be a convincing reason for deportation orders. As a result of a Supreme Court decision, immigrants having permanent legal residency, commonly referred to as green card holders, can be deported if found guilty of certain serious offenses, such as obstructing the administration of justice. The court's decision enables the federal government to deport long-term residents who have built up families here. The ruling made it clear that convictions for cover-up after the element aiming to deter victims from reporting improper behavior might be regarded significant offenses for deportation.
I hope you guys found this video extremely helpful. If you know anybody that could benefit from this information, definitely make sure to share this video with them. We are all about empowering you with knowledge. So the more people that can benefit from this video, the more people we want watching this video. If you like this video, please make sure to hit that thumbs icon. Thanks for watching. And don't forget to subscribe and hit on the notification bell for more immigration updates. Bye!